Good afternoon, everyone, and welcome to a Global Institute of Law Public International Law lecture. Today we will be talking about the law of treaties. So let's get started. In today's lecture, we are going to be discussing the formation and formalities of treaties, treaties and reservations, the validity of treaties, the interpretation of treaties, and the amendment and termination of these treaties. Let's start with the formation and formalities of treaties. When it comes to the law of treaties, one must turn to the Vienna Convention of the Law of Treaties, known as the VCLT. The VCLT outlines everything an international lawyer will need to know about treaties. In fact, it outlines everything from a treaty's function, to their formation, to their termination. In terms of the formation of treaties, the VCLT shifted the traditional thinking. Whereas traditionally, the emphasis in treaty law was equivalent to that of freedom of contract, the Vienna Convention introduced constraints and controls that had not previously existed. This meant that states could no longer enter any treaty on any terms under any circumstances, but needed to comply with strict formalities. However, before we turn into looking at these formalities, it is important to look at Article 2.1 of the VCLT. This article outlines key terms in the law of treaties which would be useful to look through very quickly before proceeding. Whilst all the articles of 2.1 are important, for the purpose of this section, I'd like to draw your attention to sections 2.1a, b, e, f, and g, which outline key definitions in the law of treaties. Article 2.1a outlines the traditional meaning of what a treaty is. Article 2.1b outlines what ratification, acceptance, approval, and accession can mean. Article 2.1e defines what a negotiating state is. Article F outlines what a contracting state is, and Article G defines what a party to a treaty will be. Now that we have somewhat of an idea of what the terms are and what a treaty is and what ratification can mean, let's turn to analyzing the formation of a treaty. The making of a treaty is usually a three-stage process involving the negotiation of the treaty, where negotiation is defined in Article 2.1e of the VCLT as a process in which states take part in the drawing up and adoption of the text of the treaty, the authentication of the drafted document, usually by signature, where Article 12 of the VCLT outlines the definition of what constitutes a signature and what steps need to be followed in order to produce a valid signature, and lastly, ratification, which is defined in Article 2.1d of the VCLT and further expanded upon in Article 14. Notably, Article 12.1 of the VCLT provides that if a treaty does not require ratification and the signature was intended to express the consent to be bound, then the signature shall be sufficient enough and ratification is not needed. Now, the difference between signature and ratification may seem confusing, so let's take a look at the difference between signature and ratification when it comes to expressing the consent to be bound by a state. In international law, a signature can express the consent to be bound by a treaty, but this is not always the case. In certain cases, consent will only occur when the signature is subject to ratification. Here, the signature does not establish the consent to be bound, but will only act as a means of authentication, which expresses the willingness of the state to continue the treaty-making process. Thus, in order for a state to express their consent, this signature must be ratified. The process of ratification will usually occur when Parliament approves of a treaty. After this approval has been granted by Parliament, the state will then notify the other treaty parties that they consent to be bound by the treaty. This common two-stage process of signature and ratification allows for domestic consideration of a signed treaty. The only obligation of a signatory before ratification is not to go against the terms of the treaty. Thus, even though they are not bound by the treaty, they should not act against it. With that, we have covered the formation and formalities of a treaty. But before we move on, let's recap the formation of a treaty. Firstly, Article 2.1 of the VCLT outlines key definitions in the law of treaties. Secondly, there are three stages to forming a treaty. 1. Negotiation. 2. Signature. And 3. Ratification. And lastly, we must be aware of the distinction between signature and ratification when it comes to consent to be bound. Now that we know all of this, Let's look at what happens when a state wants to be part of a treaty but doesn't like a certain provision and wants to change it or ignore it. When a state wants to be a part of a treaty but wants to change or ignore a provision, this is known as a reservation to a treaty. There is a crucial point to be made though when it comes to reservations. A reservation to a treaty can only occur in multilateral treaties and not bilateral ones. Now, the difference between a multilateral and bilateral treaty is quite simple. A bilateral treaty is a treaty that strictly occurs between two states, is an agreement made by negotiations between two parties, established in writing, and signed by the representatives of those parties. So an example of this can be a simple trade treaty between UK and Germany. A multilateral treaty, on the other hand, is a treaty to which two or more sovereign states are parties. Each party owes the same obligations to all the other parties, except to the extent that they have stated reservations, which is what we will be exploring now. An example of a multilateral treaty can be, for instance, the Convention on the Prevention and Punishment of the Crime of Genocide. Now, before we go on to talk about how reservations occur, let us touch upon what they are and why we need them. The definition of what a reservation is can be seen in Article 2.1d of the VCLT. As per the article, a reservation is a unilateral statement which purports to exclude or to modify the legal effect of certain provisions. Why we need reservations is quite simple. Reservations occur because sometimes it is hard for multiple states to all agree upon the same things. As such, instead of just not creating a treaty at all because they can't agree, states might be able to make a reservation to certain provisions within the treaty. Through this, the states can still be party to the treaty while still having their interests represented. The best way to demonstrate how a reservation occurs is through an example. So, let's assume that these countries on the slides are negotiating a treaty together. The UK, however, decides to make a reservation to the provision in the treaty. Historically, for this reservation to be accepted, all the negotiating states in the treaty would have to accept this reservation. So, in this case, Germany, France, Italy, Canada, and the US would have to accept the UK's reservation in order for it to be given effect. If they did not accept the UK's reservation, the UK would be left with two options: to either join the treaty as it stands, or leave the treaty completely. However, this unanimity rule proved extremely problematic when the universality of a treaty was important. Universality of a treaty can be extremely important when it comes to human rights treaties, for instance. If a human rights treaty is not universally supported, arguably its importance is undermined. As such, in order to ensure the universality of treaties while still respecting state sovereignty, the unanimity rule was adjusted under the Vienna Convention. The VCLT introduced a set of new rules. Article 19 outlined when a reservation can and cannot occur. As per this article, a reservation has to be communicated during the ratifying stage of a treaty. If it is communicated outside this stage, the reservation will have no legal standing. Article 19a then goes to clarify that if a treaty prohibits reservations, a state cannot make one at all. In these situations, the universality of the treaty is not held to be as important as securing the purpose of the treaty. Notably, Article 19c clarifies that if a treaty is silent on reservations, that is to say that it doesn't clarify if the reservations are allowed or not, it is to be assumed that reservations are allowed so long as they do not go against the purpose and object of the treaty. Article 20 continues to outline how states should act when they wish to accept or object against a reservation made. Article 20, subsection 1, makes it clear that if the treaty allows for reservations, then the acceptance of a reservation must not be communicated by the negotiating states. Here, silence will be considered acceptance. On the other hand, Article 20, subsection 2 states that if there are a limited number of negotiating states, the acceptance of a reservation must be communicated and all states must accept the reservation in order for it to have any legal effect. This reinforces the unanimity rule, however, in a limited scope and only applying to treaties where there are a limited number of negotiating states. Lastly, Article 21 outlines the effects of what a reservation does. As per this article, a reservation will modify the relation between the parties of a treaty to the extent of the reservation. So, for instance, if the UK made a reservation and Germany accepted it, but France did not, the reservation will only apply between Germany and the UK, modifying their treaty relationships. But the reservation will have no legal impact on the treaty relationship between the UK and France, as France did not accept the reservation. Therefore, the reservation will only modify the relation between the parties as to the extent of the reservation itself. So, let's summarize all this information on reservations. To begin with, reservations enable one state party to a multilateral treaty to modify the terms of the treaty for itself and yet remain a party to the treaty, although on different terms from other parties. But not all reservations are valid or permissible. If they are in conflict with the object and purpose of the treaty, they will not be valid, nor yet if the treaty prohibits reservations. In addition, where another party to the treaty objects to the reservation, the effect, depending on the intentions of the objecting state, will either be that the treaty does not operate between itself and the reserving state, or that while the treaty remains in force, the provision to which the reservation is made is not operative between those two parties. And with that, we have now gone through how to formulate a treaty and how to create a reservation and the effect of reservations. Let's now turn to the validity of treaties. When it comes to the validity of treaties, Article 26 of the VCLT is at the heart of it. This article states the principle of pacta sunt servanda. This Latin phrase provides that every treaty in force is binding upon the parties to it and must be performed by them in good faith. As such, under the VCLT, the validity of a treaty can only be impeached by using the provisions of the VCLT itself. As such, the VCLT provides for 3 factors which will make a valid treaty invalid. These factors are, firstly, error, fraud, and corruption. Secondly, coercion of a state or its representatives. And lastly, treaties conflicting with the peremptory norm. We will now turn to look at each one of these factors individually. Let us start with error, fraud, and corruption, which can be found in Articles 48, 49, and 50 of the VCLT. Error, which is under Article 48 of the VCLT, relates to a fact or situation which was assumed by the state to exist at the time when the treaty was concluded and formed as an essential basis of its consent to be bound by the treaty. But this will not apply if the state in error contributed to the error on its own. Next, we have fraud, which is found under Article 49 of the VCLT. Article 49 provides for invalidating an express consent to be bound to a treaty if a state has been induced to conclude it by the fraudulent conduct of another negotiating party. Last, we have corruption, which can be found under Article 50. Article 50 provides similarly where a state's consent has been procured by the corruption of its representatives. So if Article 48, 49, or 50 are found to have been practiced when consent to be bound was being formulated, the treaty will go from being a valid treaty to an invalid treaty. Next, we have coercion of a state, which can be found under Article 51 and 52. As per Article 51, where a state's consent to be bound by a treaty has been procured by the coercion of a representative through acts of threats directed against him, that expression of consent shall be without any legal effect. Article 52 goes on to explain the use of force. So Article 52 states that a treaty is void if its conclusion has been procured by the threat or use of force in violation of the principles of international law embodied in the Charter of the United Nations. So similarly again, if coercion has been used or the state representative has been threatened by a use of force, the validity of the treaty will be null and it will go from a valid treaty to an invalid treaty. Next and lastly, we have what is known as Peremptory Norms or use cogens, which can be found under Article 53. Article 53 provides that a treaty will be void if it conflicts with a peremptory norm of international law, which is defined within the article as a norm accepted and recognized by the international community of states as a whole as a norm from which no derogation is permitted. The Commission considered listing examples of peremptory norms, but concluded that to do so might appear to prioritize or privilege those listed. However, an example of a peremptory norm would be human rights, or the use of force, or the use of torture. So, all of these norms are considered to be an absolute hard no in international law, being that the use of torture is absolutely prohibited. It is a jus cogens. There can be no derogation against this specific type of law. So, if an article or a treaty conflicts with this type of norm, it will immediately go from being a valid treaty to an invalid treaty. With that being said, let's quickly summarize the validity of treaties. To begin with, the principle of pacta sunt servanda underlies this treaty law. There is recognition that rules are necessary to ensure the validity of treaties and to provide the circumstances in which an apparent treaty may be void. And these rules are error, fraud, and corruption, coercion of a state, and peremptory norms. If any of these three underlying causes are found to have been practiced whilst a treaty was being formulated, the treaty will immediately go from being a valid one to an invalid one. And this is all provided for under the VCLT, with the underlying umbrella of pacta sunt servanda carrying this all through. Now that we have looked at the formation of a treaty, the reservations in treaties, and the validity of treaties, let us turn to examining how we interpret treaties. The art of treaty interpretation is not dissimilar from that of statutory interpretation in domestic law. Problems of interpretation, however, arise where treaty provisions are ambiguous, unclear, or contested. Historically, in international law, different rules of interpretation were applied in particular circumstances. So, for instance, the first step would be, when interpreting the words of a treaty, the words should be given their common meaning, so long as this common meaning was uncontroversial. Next, if this didn't suffice, the teleological approach would be applied. This approach would consider the objectives of a treaty and what interpretations would best satisfy those objectives. Notably, this was a two-step process, and whilst it was sufficient and unproblematic, the VCLT decided to take it a step further, and they came up with their own approach, known as the ordinary meaning approach. Now, the ordinary meaning approach of the VCLT can be found in Article 31. As per this approach, a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in light of its purpose and object. Thus, object and purpose will not be irrelevant. This meant that stage 1 of the old process, which was giving words their ordinary meaning, would be applied, but the teleological approach was also applied by making sure that all of the words were analyzed in context in light of the object and purpose of the treaty. This thus then combined the old approach, which was a two-step approach, into a one-step approach now enshrined under Article 31 of the VCLT, known as the ordinary meaning approach. So let's summarize that all very quickly. Treaties are interpreted by applying a number of not necessarily consistent rules. While the first task is to give the rules of the treaty their ordinary meaning, it is equally important that the intentions of the parties be identified and the object and the purpose of the treaty be achieved. And this is exactly why Article 31 of the VCLT was written, the ordinary meaning approach, which allows both for the object and intention to be considered. And with that, you now know how to formulate a treaty, understand reservations, understand the validity of treaties, and now how to interpret treaties as well. The last step of the treaty making process is to consider how treaties can be amended and terminated. Often, the treaty itself will provide either for its termination or will define the circumstances that will bring it to an end. Despite this, the VCLT provides for three main non-consensual grounds that may lead to the termination of a treaty. These are material breach, supervening impossibility of performance, and fundamental change of circumstances. Let us look at each one of these non-consensual grounds in turn. Let us start with material breach, which is defined under Article 60 of the VCLT. VCLT defines a material breach as a repudiation not sanctioned by the present convention, or the violation of a provision essential to the accomplishment of the object or purpose of the treaty. Now, what happens when a material breach occurs? Either it entitles the party not in breach to invoke the breach as a ground for terminating the treaty or suspending its operation in whole or in part, or it allows all the other parties by unanimous agreement to suspend the treaty in whole or in part, or to terminate it either as between themselves and the defaulting party or among all parties. Or lastly, a single state especially affected by material breach may invoke it as a ground for suspending the operation of the treaty in whole or in part in relations between it and the defaulting state. So, if a material breach occurs, this can terminate the treaty. Next, we have the supervening impossibility of performance, which is defined under Article 61 of the VCLT as the impossibility of performance resulting from the permanent disappearance or destruction of an object indispensable for the execution of the treaty. Notably though, this article may not be invoked if the impossibility is the result of a breach by the party wishing to terminate either an obligation under the treaty or any other international obligation owed to any other party to the treaty. Additionally, if the performance has become considerably more difficult than it could have been foreseen by the parties at the time of negotiation, it is also insufficient to terminate it on this ground. So the scope of this article, while it may seem to be quite wide, has actually been considerably narrowed. And lastly, we have fundamental change of circumstances, which has been defined under Article 62 of the VCLT. It is clear that while Article 62 provides for termination in the event of a fundamental change of circumstances, instances of termination are few and far between. Change of circumstances may only be invoked as a ground for terminating or withdrawing from a treaty if the existence of those circumstances constituted an essential basis of the consent of the parties to be bound, and the effect of the change is to radically transform the extent of obligations still to be performed under the treaty. So once again, whilst the merit of this article seemed wide, it has been considerably narrowed in practice. So in summary, when it comes to the amendment and termination of treaties, it is usually outlined within the treaty itself. But the VCLT has put forward three non-consensual grounds for termination. These are material breach, supervening impossibility of performance, and fundamental change of circumstances. And as we have seen, that while these three non-consensual grounds for termination may seem broad, in reality their scope has been considerably narrowed in practice, and the termination of a treaty on non-consensual grounds is extremely difficult. So, in conclusion, we now know the law of treaties. We have gone from formation to reservations, to validity, to interpretation, and finally, amendment and termination. Let's do a quick recap of that all right now. When it comes to the formation of a treaty, there are three stages we must consider. When it comes to reservations, Article 19 to 23 of the VCLT is where we need to be looking. When it comes to validity, we now know that pacta sunt servanda is the umbrella which underpins the terms of validity in a treaty. Interpretation, we now use the ordinary meaning interpretation, which is also codified in the VCLT. And lastly, when it comes to amendment and termination, the amendment and termination are usually defined within the treaty itself, but when they are not, we once again turn to the VCLT and the non-consensual breaches which they allow for. So in conclusion, when it comes to the law of treaties, the Vienna Convention of the Law of Treaties cannot be overlooked. Everything we need to know has been codified within that convention, and we cannot stray away from it. I hope this presentation was useful, and make sure to keep an eye out for the Global Institute of Law and other presentations which are to come. Thank you.